Hey folks, James Abrenio here, owner of Abrenio Law, your Northern Virginia personal injury and criminal defense law firm. In this video, I wanted to answer a question that I get a lot. James, what happens after I file my lawsuit in my Virginia car accident case? It's an often asked question. It's a very good question, so I'm going to take a few minutes to hopefully teach you, make sure you follow along. And in order to do that, I've got a nice PowerPoint for you. But before we begin, here's my information, www.abreniolaw.com. My email is there as well. If you ultimately find this video useful, make sure to subscribe to this YouTube channel. If you're seeing it on our website, you can actually navigate over to YouTube. Absolutely feel free to share this as well. Our goal is to create useful content to help people navigate their car accident cases. We also do a lot of other informational videos, so if you have a question about personal injury or criminal defense law here in Virginia, this is the place to go. So with that said, let's get started. So before we talk about what happens after we file a lawsuit, the question that usually get is, James, why do we have to file a lawsuit in the first place? And I'm going to note a couple reasons here. The first being, obviously, because settlement negotiation with the insurance company didn't work out. I always tell people, look, our goal in representing you is to present your case fairly, to give the insurance company as much information as they can, and to advocate for you. But what I cannot do is ever force an insurance company to treat you fairly. Indeed, in many instances, the reason I have to get involved is because of that. The insurance company isn't taking your case seriously, so I have to get in and try to force a higher settlement. But if they don't ever come to a reasonable amount, unlike a real estate deal, for instance, you're trying to buy a house and they won't come to the right price, there you walk away from the table. What I like about litigation is you can file a lawsuit, enforce them in the court, enforce them in front of a jury, and if we don't get the right answer from the insurance company, we'll try to get it from a jury. So another reason that you may have to file your lawsuit is because the insurance company outright denied your claim. Let's say, for instance, they're trying to claim that it's your fault. Virginia is very apt for this, and what I mean by that is we apply something called contributory negligence. That means that if you're just 1% at fault and the other party is 99% at fault, you lose. So just because an insurance company's denied your claim doesn't mean that you've lost. Indeed, that's another reason we may march into court and see if a jury or a judge disagrees. The next reason that you may have to is, for whatever reason, you need to file discovery in your case. And what that really means is, essentially through the litigation process, through subpoenas, through depositions, we'll talk about more, we're able to get more information about your case. There may be a reason that we can't get it without actually filing a lawsuit, so there may be more information before we even know if your case is a good one to settle. Let's say, for instance, maybe there's different parties involved that may have access to additional coverage that wasn't from just this one defendant, but there's a whole host of reasons you may need to file for discovery reasons. The other thing is your statute of limitations is running. And what do I mean by statute of limitation? And I've shot a video in detail of this, so feel free to go back to the YouTube page to find that video. But a statute of limitations here in Virginia is essentially, it's the deadline for your case. If you miss it, you lose. You waive your claim is barred. So a lot of times I'll have cases that I'll end up filing in court to make sure that I toll that statute, meaning I suspend it so it's not hurting you. So I see this in a lot of cases where there's serious injury. Let's say somebody's has a broken bone that required surgery, and there's permanency and extended treatment. I've had cases where there's a surgery, but then that didn't heal, so they ended up having to do multiple surgeries, or permanent injury, and you may need additional time to recover, or you just haven't, for whatever reason, settled the case, and filing the suit allows you to toll that statute of limitations. So I will also note, there may be other reasons that you have to file a lawsuit. These are the ones that really come to the top of my head at this moment, but again, this list is not inclusive. This video is really informational, so this is really, I'm trying to highlight the best I can right now, the main reasons, at least in my anecdotal experience, as to why you might need to file a lawsuit. So What happens after suit is filed? And that's really the crux of what this video is about. It's really to give you, whether or not you're an Abrenio law client or you're out on the internet and on YouTube just trying to figure out what's going on in your case and you just want better clarity. Maybe your attorney's not being as clear with you, but they're doing a great job, but they're not really just kind of telling you the after the fact about what happens after filing suit. So let's go ahead and get started. Now, what happens is when you file your lawsuit, what I'm talking about is you literally taking the paper document that claims negligence. In car accident cases, it's typically going to claim negligence. There may be other claims there like punitive damages, but you literally are taking the physical suit and filing it at the courthouse, and it's sitting in the court file. But that doesn't actually get the case moving. Again, it tolls the statute of limitations, but in order to actually get the case moving, you've got to literally file those or serve those documents upon the defendant. And what do you mean by serve? Serving literally means giving them official notice. Hey, you're being sued. This is how much you're being sued, and here's it by who, and you have certain deadlines you need to meet, and if you don't meet them, you're going to lose. You're going to get a default judgment against you. In order to effect service, a couple things have to happen. Number one is we need to obviously know who the defendant is and where their physical location is. Under the Virginia statute, you can serve them in person. You can also, if it's done, if other statutory requirements are met, you can serve them at their last place of living or at their actual house. And there's other reasons, other methods of service by the statute. For instance, let's say a defendant is out of state, an out-of-state driver, you can actually serve them through the DMV, the Commission of the DMV. But usually this takes a couple weeks. Essentially, the attorney, I would file the suit. The court actually takes a few days to a couple weeks to actually prepare the document in addition to the lawsuit that attaches to the document. It's called the summons. And then I get that back and then I send it to my process server and get that done. Again, the court usually takes a week or so to get the summonses to me, but then the next kind of delay may be if we can't, let's say we can't find the defendant and we've got to hire a private investigator to investigate that. But if we know where the defendant is, it's usually a couple-week process. It's not a huge delay. So once the defendant is served, by Virginia code, by Virginia statute, they have 21 days to reply. If you actually saw the physical summons, it would literally advise them of that. Whether or not they actually reply in 21 days, let's say I serve a defendant, they give it to their attorney reaches out to me and says, hey James, my deadline is next week, can you give me a couple more weeks? So long as the defense attorney is reaching out to me and being communicative, the 21-day deadline, at least in my view, can be flexible so long as they don't violate the 21-day deadline. And the reason I do that is, number one, it's courtesy. The defense attorney is usually not getting this document until very shortly before the deadline is due. I'm going to be having to work with this attorney throughout litigation. The last thing I want to do is be unreasonable, and there may be deadlines that I need extensions on. So if I start the ball game off harsh, unreasonably harsh, we can expect that on the back end. I will also say courts are very reluctant to allow us to win simply because the defendant didn't meet the 21-day deadline. Indeed, a lot of times they'll give them they'll grant them leave to file a complaint late. And again, it's really for these logistical reasons. Maybe the document has been served on the defendant. The defendant didn't really know what to do with it. It took a couple weeks to get the attorney involved, to get to the insurance company. So logistically, the courts are going to be a bit more forgiving for them. So what happens next? When they reply to your lawsuit, and by reply also what I mean is they literally responding to the complaint in the allegations in your complaint. So our lawsuit's going to say, defendant was driving in Fairfax County, ran the red light, injured, crashed into your vehicle. They violated these statutes in doing so. They were negligent in doing so, and because of that, you suffered severe injury, lost wages, XYZ. In their reply, they're literally going to go paragraph by paragraph responding to your complaint. And I will say, typically, they're going to either say we deny it, or we don't have enough information to respond to it. For instance, that you've suffered $5 million in damages. It's going to be too early for them to know that, and I think that's a sincere reply of we deny and have facts insufficient to respond to that. But they're typically going to reply. But with that, they're also going to serve upon us what we call written discovery. And we'll talk about this in a bit more detail, but written discovery is really two documents. The first is interrogatories, which I call their ROGs. The second document is request for production of documents, which I've abbreviated there as RPDs. Essentially, these are kind of common sense documents that you would expect to receive if you've sued somebody. Essentially, their interrogatories are literally written questions to you saying, tell me about how the accident happened, tell me about your injuries, tell me who you saw, and all that. They're also going to serve upon us requests for documents, which again, you would expect them to ask for. Give us your medical records, give us your medical bills, give us any pictures of property damage, any witnesses you may or may not have, those kinds of things. And I will say a lot of times when we get written discovery, I, the attorney, will help come up with an initial draft, and then we'll work on that. With the response request for production of documents, usually I've already had a lot of those, especially if we've already tried to settle your case by way of a demand letter, trying to negotiate it. We've already even given that to the insurance company, but when the defense attorney is involved, they'll ask for those documents again. A lot of times the insurance company, let's say they're working for Geico or USAA, the adjuster actually doesn't hand off the file, and the attorney that's working for them, that's defending the defendant, hasn't ever even seen these records before. So they're going to be thorough in asking for it, which is absolutely reasonable. Now, just like they had 21 days to respond to our reply, we're going to have 21 days to respond to their written discovery. And again, we'll talk about this in more detail. And when we respond to their written discovery, typically what I'll also do, at least my process is along with our responses to their discovery, I'll send my own set of written questions and requests for production of documents to the defendant. In a typical case, a typical car accident case, I will say my written discovery is usually less thorough than or less voluminous than the defendant's is upon us. And the reason being, the discovery that they're trying to get is a lot more dealing, in many instances, dealing with your injuries, your medical treatment, your recovery. All I'm trying to figure out is who the defendant is, why the accident happened, their version, and really are they trying to claim that you contributed to the accident. So our issues at trial are narrower than the defendant's. We're just trying to establish liability that they're at fault from the defendant, whereas they're trying to defend both the liability as well as your injuries and discovery about your injuries, and trying to, I will say ultimately they'll probably try to deny that your injuries are related or not as serious as you claim them to be. Now, the next thing that happens, and this is simultaneous with the reply being filed, the written discovery being issued, and us working on that, is once the case is served, usually a trial date will get set 9 to 12 months after the case is served upon the defendant. Whether or not it's closer to the 9 months, whether it's closer to 12 months, a lot of it's going to depend on a particular jurisdiction. Places like Fairfax, it's going to be on the quicker end typically because they've got a lot more judges and they're just a quicker docket. Places like Charlottesville, for instance, it's going to be closer to 12 months. And frankly, a place like Charlottesville, I've had cases not set out until 18 months, sometimes 2 years, because it's such a small courthouse and they've actually got a relatively fair amount of cases, so it just takes longer physically for the case to get up on the docket. But 9 to 12 months kind of gives you a general idea of what we're talking about there. And again, some jurisdictions are different. A caveat though, right now as I'm shooting this video, it's July 10th of 2020. We're kind of in the depths of COVID-19, and we're in kind of a weird situation that's throwing off all these typical numbers because the courts yet aren't sure what to do with COVID, not sure how safe it is to have trials and people in the courthouse. So we're still working our way through that. Once that clears up, again, I think it'll go back to the 9 to 12 months once everything gets oriented again. But right now, again, a caveat with this, and a caveat with this video is I'm doing my best to give you an idea what typically happens when things are running normally. So just be aware this video is important, but while COVID is still around and we're uncertain, these deadlines are going to be adjusted a bit. So what happens next? And this is kind of a follow-up to what we were talking about before, the discovery. And what I meant by that is, first of all, the written discovery. Again, we talked about this already: interrogatories, requests for production of documents, also something called a request for admissions in some cases where we're essentially, or they're asking for facts to be admitted to. Those are done, but your main involvement and what you'll be seeing is the interrogatories and requests for production of documents. Again, as we talked about, will help you prepare the interrogatories, answers to the defendant's interrogatories. We'll help and work together getting the documents they're asking for. And also, I will be reviewing their answers to our interrogatories, their answers to our requests for production of documents. And if I feel that they're insufficient, what I typically will do is send what we call a deficiency letter, essentially saying, hey, your answers to 1, 2, and 5 are insufficient. Here's the reason why. By the way, you've also not produced these documents, and here they are. And if either we don't fully answer to their liking or they don't fully answer to our liking, we can both file what we call motions to compel, and we'll have discovery fights within the court, and judges rule on that. You, the plaintiff, if you're our client or if you're working with another attorney, you're typically not really involved in fighting over sufficiencies of answers and things like that. You're not going to court for these motions. The judges don't want you there. There's not really a reason for you to be there, but we, the attorneys, will deal in that. Now, the next part of discovery, and discovery just kind of blanketly is kind of what it sounds like. It's an effort by parties to discover information about the case. And in addition to written discovery, there's really live discovery, and that's really just a term that I'm using right now. Other people may call it something else, but what I mean by that is really deposition. So the first is party depositions. As you can see there, it's really the defendant and the plaintiff, you the plaintiff, and we will, in most cases, take the defendant's deposition as well. In many instances, it'll be at the same time. The defendant will go first, and then you'll go second. And I want to be clear, and we'll do more videos about this. A lot of people come to me and they're worried about depositions. Don't worry, we will help you prepare for depositions. I typically will have you in the office. We'll sit down at the table. We'll go over the questions. We'll help kind of you to articulate them well. Again, I'm not going to be answering for you, and it's exactly what I can do at depositions. That's subject for another video, but we'll make sure you're well prepared for that. With COVID, again, given how it's being done right now, sometimes these depositions I've actually been doing over Zoom, and it's been working out well, so we probably do video preparations by Zoom as well. You can share documents and all that. As you can see, video technology is great, so it's usually not a difficulty. If something weird happens where we need to meet, certainly will. But typically, without COVID situation, we're meeting in person. We're actually running through questions that are going to be asked. And I always tell people, don't memorize the questions that I'm asking you. It's really just kind of a general idea. But the depositions are kind of what you would expect. They're really an extension of a written discovery. And so we'll get that done. There will also be other witness depositions. So let's say there's an independent witness that I need to be able to learn about, or maybe you have witnesses that are going to support your testimony. Those, again, may or may not be done at the same time as the party depositions, but those will be done. And in the standard rear-end car accident case, or the typical kind of run-of-the-mill car accident case, there won't be a whole lot of witness depositions, but if for a complex injury case or a complex accident case, meaning the mechanics of how it happened, there may very well be a lot of witness depositions. Not so much in car accident cases, but I have a lot in my slip and fall liability cases, premises liability cases, some med mal cases. I don't do employment law, but employment law witnesses' depositions are very thorough, and there's usually a lot of them. And another type of live discovery is corporate depositions. Again, for the run-of-the-mill car accident case, there's not going to be a whole lot of corporate depositions going on, but maybe there is. But again, preparing for live deposition, you as the plaintiff, you as our client, we will do the heavy lifting for that. We will be the ones preparing the questions for the defendant and witnesses, obviously, and then we will also help prepare you for your deposition. So don't worry about it. If you're working with Abrenio Law, part of the reason we're creating this video is to help you get prepared. We'll be just as thorough in the witness deposition prep for you, so take heed, it will be just fine. Now, the next part, and again, this is all happening within that time frame that we talked about from the case being filed to the actual trial date. And again, typically that's 9 months to 12 months depending on the jurisdiction. But all this discovery I'm talking about is happening within that window. And so the next type of discovery is expert witness discovery. And what do I mean by that? With every lawsuit that's filed and then a trial date happens, there's going to be something called a discovery order entered. A discovery order is essentially a timeline issued by the court on when things are due. And the first thing that is due, in addition to the 21-day rule we're talking about in responses, is typically 90 days from a trial. Our plaintiff's expert designations are due. And that's in most counties. It may be different in different jurisdictions. But you may be asking, well, what is an expert designation? What is an expert witness? What is an expert designation? First of all, expert witnesses are typically going to be who you think. Number one is going to be your treating doctors if they're needed, or if we have to hire an independent doctor to evaluate you after the fact, and then they're going to be ultimately the ones coming to trial. For my cases, I typically like to have your treating doctors, if at all possible, because they're the ones who know your case. They're the ones that are supporting you, treating you. They don't have to review files except their own that's really relevant to the heart of it. They put their hands on you, so they're going to be the best witnesses. But in many instances, and you may unfortunately learn the hard way, a lot of expert witnesses don't want to spend their time in court. They'd rather spend their time treating patients. They don't like attorneys like me, which is understandable. Sometimes they won't want to come, or sometimes we need additional independent witnesses for whatever reason, because your injuries are different or unique, and so we'll hire a different doctor, and that's really on the medicine side of things. There may be other expert witnesses depending on the complexity of your case, and that's kind of outside the scope of this video, but for the purposes of what we're talking about here today, expert witness, think about if this is kind of a straightforward car accident case, and I don't mean straightforward in the sense that you haven't been through a lot. I mean procedurally, meaning you got injured, you were treated by doctors. This is really going to be the heart of the expert witnesses. Now, what is an expert designation? So I kind of referenced that earlier, but an expert designation essentially is a document that we give to the defense, where we tell them exactly what we expect our experts to testify to. And you'll see there's three main areas right there. The expert's qualification, for instance, where they go to medical school, what certifications they have, where they're licensed. The next part is a summary for the basis of their opinions, and that's usually going to be all the documents reviewed, if they did a physical examination of you, if they treated you, and their understanding of the case is total. And just so you know, to prepare for this expert designation, what we at Abrenio Law do is we typically, once we've secured an expert agreement they're going to help, is we're actually sending them all the documents in the case so they can review those, whether it's their own medical records or their other medical records, photographs of property damage, the police report, depositions. We're working with that expert witness to prepare this expert designations behind the scenes. So unless there's something weird going on with your doctor, meaning they won't cooperate, or there's something weird about what we think their testimony is going to be, you're not going to be really involved in this. But we're communicating with that doctor to make sure that they're fully aware of the case, because the last thing we don't want and we want to avoid is, let's say they didn't see a document that may be hurtful. For instance, let's say you're claiming that you had a knee surgery due to the accident, but a year before you had knee pain, and there's a medical record. I want that doctor to see that, because number one, if they're going to say, well, now I can't say your knee surgery is related to the case, I want to know that. But number two is, if they still see that and despite that still believe that your knee surgery was related to the case, it's going to help bolster their opinion, because and I'll bring that out in their testimony, because they're not essentially operating in the dark, or the defense attorney can't argue they're operating in the dark because they weren't aware of some important fact like a pre-existing issue. And also, the designation is going to give a summary of our doctor's opinions, meaning what do they believe your injuries were, what do they believe the bills and treatment related to the case, whether or not they believe that you're going to actually need future care, and we need to lay that out in much detail. My goal in the expert designation is to lay that out as much detail to the other side, because number one is I want my doctor prepared, so when there's detailed expert designations, that's helpful. But number two, the last thing that I want is a defense attorney being able to go to the court and say, Your Honor, Mr. Abrenio and the plaintiff failed to properly designate this expert witness's opinion. They didn't tell me that they were going to opine that there was a permanent injury, or that they thought that this related to the case, XYZ, whatever. And by not including it in the designation, we risk a judge excluding that testimony. And if our expert witness is excluded from testifying, no matter what we've given in written response to the defendant's request, in my view, what really matters is what happens at court. And if an expert witness can't testify, that may very well severely damage our potential of winning at court. So we want to do our best to designate clearly and thoroughly. Now, let's take a second to talk about the defendant's expert witnesses. And just like we're going to have expert witnesses, if the defendant's going to make claims, for instance, your injury is not related to the case, or you overtreated, that kind of thing, they're going to have to designate theirs. Now, as I said before, ours is typically due 90 days before the trial. In response, in most jurisdictions, theirs is due 60 days before trial. And what I will say about this, when we look at the 90 days for us before trial to designate versus their 60 days before trial to designate, I will treat my 90 days as absolutely mandatory, and I never want to be in a position where I'm asking the defense attorney for an extension. Number one is I don't like to operate like that, but number two, I will say, at least in my experience, the courts are more lenient to the defendant's expert designation being due 60 days before trial than they are ours being due 90 days before trial. And the reason that is, and we'll probably shoot another video independent of this about this, but is because we have a right to what we call a non-suit typically in Virginia. What that means, and this is a Virginia state case, we're talking about if your car accident's in Virginia, we've filed in state court, whether it's Fairfax County, Arlington, Charlottesville, wherever. Under the statute, we typically have a right to drop the case and then refile it, so long as we do that within 6 months of that drop. Because of that, if we miss our 90-day deadline, most courts are going to say, well, you can always non-suit it and refile it. The defense doesn't have that same opportunity. They never get a chance to non-suit it. So I can force them to trial, and because of that, the courts are usually more lenient to give them flexibility. So that's what I will say in practice. If a defense attorney is being communicative with me, if they've been reasonable throughout the case and they have a reason to not meet that 60 days, or I've worked with them before and I know them to be reasonable, I usually will give them an extension. Number one, again, because the courts are probably going to give it to them, but number two, again, where we can show flexibility and not fight on things that, number one, we're probably going to lose in court, but also we don't fight on things that don't matter, even if it seems like we're, quote, giving in. My view is being kind to the other side ends up, number one, increasing the likelihood of fair settlements, but number two, it makes it easier if we need help. But number three, if there's something that comes in the court, we can also tell the court, hey, look, Your Honor, we gave them a break here, we're asking for a break there, that kind of thing. So my view is if it's not worth fighting over, we don't have a strategic benefit by fighting over it, I'm not going to go there. So we'll typically give them an extension if they need it. Now, the next thing is who are the defense expert witnesses? And I kind of jumped the gun a little bit there, but look at the second tab right there. Who are the defendant's expert witnesses? As you know, which kind of is logical, they're going to be independent doctors because they've never treated you before. They wouldn't have. If they've had, they would not be able to testify at trial. So inherently, they're going to be independent doctors. I will say they're usually going to be doctors that have done a lot of defense work. They know the game. They know how to testify. Part of their practice is usually part forensic testimony in car accident cases. So I can tell you in an anecdotal experience, we oftentimes are seeing the same defense attorneys come up and back and forth, and it makes sense. The insurance company usually has a list of doctors they like using, and so they'll give them work. And so some are more fair, some are completely willing to say whatever the defense says and everything in between. What I will say is I can expect in most cases if they're getting an expert witness, they're using an opine something that's not as good as what our expert is saying, meaning they're going to undersell your injuries and treatment, all those kinds of things, and that's just kind of off the bat. So sometimes I've been surprised and they've agreed, but you can expect in most cases that the defense expert's going to testify against us and not be great for us. And what do the defense expert witnesses base their testimony upon? They, just like our doctors, will review the medical records and bills and other documents from the case, just like I'm providing our doctors all the files. The defense attorney is doing the same for their doctors, and for the exact same reason that we're doing it. Number one is they want their expert to be fully aware of the case so they can properly form their opinions, but they also want to avoid being cross-examined by me. They don't want to be in a situation where I get to say, hold on, doc, you're telling me you didn't see medical record number 3 from January 4th of 2017. Well, how can you really have an opinion if you missed this important document? So they're going to do their best to give them all the documents as well. The other thing is they may have a right to what we call an independent medical examination. And what I mean by that is they can actually compel you to go into their office to where they can physically examine you. And you may say, well, James, that's not fair. Why do I have to expose myself to that? And when you think about it, it makes logical sense. If you're suing an individual and claiming injury, they have a right to figure out whether or not you're really injured, right? And you can imagine you getting sued. The defendant is claiming they needed surgery. The first thing you're going to say is, well, how do I know that they actually needed surgery because of this? Maybe they're trying to milk something else. So they're going to have a right in most cases to have an independent medical examination of you. I will say, though, I usually argue that in order for this IME, there has to be a medical need at issue. And what I mean by that is we're saying, hey, my client has ongoing permanent injury, they need future treatment, and all those kinds of things. So a medical examination now would be relevant if let's say you're claiming that you still need physical therapy for your knee or you need future surgery for your knee. In my view, it's more likely that an IME would be helpful because they can physically observe, the doctor can physically observe what's going on with you. I've argued in prior cases where, let's say we've filed suit and we're saying my client, the plaintiff, is completely recovered. I've argued that an IME isn't relevant because there's no ongoing issue that the doctor can really opine upon. Let's say you've claimed a brain injury, for instance, and you're no longer claiming a brain injury. Well, what's it going to help if the doctor's examining you a year after you recovered? That's my argument. Now, for the cases that I deal with, it's usually very complex injuries, even there's a recovery before trial, and we're usually suing for a lot of money. So let's say we're suing for $500,000. I can tell you the courts and the judges are usually going to give them that IME, even if I'm objecting to it, just out of abundance of caution. Frankly, it's probably better that they're doing that, because the last thing that I want to do is win a huge judgment against the defendant. They were denied an IME, and then they go and appeal the case, and all of a sudden the Court of Appeals rejects and says that was improper and we need to do a new trial. That's the last thing I want, but I will argue it where it's relevant. The next thing is the weeks and months leading up to your trial date. And what do I mean by that? Now, I want to be clear, the discovery we're talking about, whether it's written discovery, request for documents, live discovery, in most jurisdictions the discovery closes out 30 days before trial. And that usually is included in that scheduling order we talked about way back when. So you need to be aware of that. And but I, the attorney, will absolutely be aware of that, because it's certainly important for your case. And so that's what's going to happen there. Now, during the months and weeks leading up to your trial, I, the attorney, will be preparing for your case, and many of these things, again, I'll be doing behind the scenes that you're not aware of. For instance, witness subpoenas, organizing documents and images, getting things ready for exhibits, that kind of thing. Also preparing exhibits and all that. So I may or may not be having you help me. A lot of times I'll be asking you for other documents if we needed, that kind of thing. But especially within the 3 months leading up to trial, as we're reaching that closeout of discovery deadline, I want to make sure I've got everything disclosed to the defendant and everything ready and organized, because my biggest fear is we don't give them some document or some picture or list a witness, and then at trial they say, well, they never disclosed this in discovery, therefore they can't present it and the judge agrees with them. So we will also do witness preparations. Number one, you, the plaintiff, don't worry. Again, just like deposition prep, we are going to have you in the office or by Zoom or however it happens. We're going to have you prepared to testify. So don't worry about being scared and us just kind of hanging out there to dry. We'll prepare you. We'll also prepare all of our witnesses. Witness to the accident, witnesses, whether it's family or friends, supporting your injuries, recovery and treatment, whether it's your boss talking about your lost wages, and also your expert witnesses, as we were talking about before. Just like we're preparing them for the expert designation, we're also going to prepare them to testify. Now, doctors are usually at least somewhat involved in trials, even if there are independent doctors or treating doctors. Some have less experience than others. But what I typically do is I will actually meet them in their office, or at least a video conference where we're preparing their testimony. I'm kind of giving them an idea of the questions I'm going to ask. Sometimes I'm going to ask them specific ones, especially if there's a piece of evidence I definitely want them to be able to testify about. I'm going to make sure that they're ready to testify about that. I'm going to show them pictures if they're going to use exhibits. So this meeting is usually 30 minutes to an hour. We typically have to pay for it. I'll typically let you know when that's happening and all those kinds of things. And if there's some issue that comes up as well, at least I've met them in person and we can deal with that. And also, just as kind of a persuasive ability, I always find it's best to know your witnesses, to have met them, when possible to shake their hand or at least seen them face to face. So I want to be well prepared so everything at trial goes fluidly. Now, another deadline, now discovery, again, as we talked about before, closes 30 days before trial, but another deadline is a witness and exhibit list that's due 15 days before trial. Essentially, this is a document where we're telling the defense, this is who we expect to call at trial. This is the documents we expect to use. And what I will say about that is it's always better to over-list than not list. So let's say there's 5 people we may want you to testify for you at trial. We're not sure if everybody's going to get there. I'd rather list all of them. And that way whoever comes rather than not list somebody that we may want to use, because again, the defense will argue it wasn't disclosed and we're going to maybe have them excluded from trial. Same thing with exhibits, documents, medical bills. We want to make sure that we've disclosed everything that may be an exhibit. And to be honest, I typically will do my best to prepare this exhibit and witness list before 30 days before trial, before that discovery cutoff, just so If they try to say we didn't give it to them before or something inadvertent happened, we've now given it to them before the 30 days. And also, jury instructions are due 5 days before a trial. Again, you're not going to really be involved in that, but essentially, jury instructions, again, that's going to be subject to another video, is really literally the instructions that are read to the jury. Both I and the defense have to give proposed jury instructions. Again, you're not going to be really involved in this. This is something behind the scenes. But if I want a jury instruction, I've got to propose it. If the defense wants a jury instruction, they have to propose it. In many of these cases, especially the run-of-mill Ottawa cases, and again, I don't mean to undervalue your case, I'm just talking about the process. Most of the jury instructions are kind of the by-the-book jury instructions, and actually there is a jury instruction booklet where most of them are going to be agreed to, but there's going to be a few that's going to be argued, but we have to propose them all, meaning give them to the defense 5 days before, and then we'll argue, and the judge won't decide which ones come in until actually at trial after all the evidence has come in, and he'll determine which ones are appropriate, and we'll be arguing with the court about which one's appropriate. So now a question that is natural is, well, James, you're talking a lot about trial. You've told me that after the case gets served, there's 9 to 12 months in most typical cases that the cases go to trial, but is my case going to settle? Why are you talking about trial? And I will say most cases do settle. I want to be clear about that. Most cases do settle even after we've filed suit. Most cases will resolve by settlement. But what I will say is this: we're going to be prepared as if we're going to trial. What I never want to be in is a position where we've just assumed the case is going to settle. Now, I'm not going to talk about all attorneys. The attorneys that I know, that my colleagues, are trial attorneys. They're ready to try a case. But the reason I'm friends with them is because we kind of have the same philosophy. And a lot of times we'll talk about what happened at trial techniques. We like going to court when needed and when it's appropriate. But there are some that I hear through the grapevine, and I've seen reports on they're not prepared for trial. And I think this is a disservice to you, the client. So I don't want to make you nervous. A lot of times I'm so thoroughly preparing that I make my client nervous and all that. The reason we're doing this is to be prepared for trial, but also I will say the better prepared for trial, usually the better settlement offers, because the defense sees that preparation and they appreciate it. And they're worried about losing at trial. Now, what are the timings when the possibilities heighten of settlement after filing a case? And you see a list popped up, and I'm going to pop it up just again. What I will say about these time periods, they're really my anecdotal experience based on my experience. I've been handling personal injury cases for over a decade now, and at least I've seen patterns. This isn't the end-all, be-all. Things happen, different cases are different, proceed differently, but this is kind of where I see kind of highlights in when cases may settle. The first is immediately after suit and the case gets served. The reason I believe that happens is the case actually goes to an attorney, and the attorney has the opportunity to actually evaluate the case, and they'll say, well, wait a minute, we need to get this thing resolved. The adjuster either didn't appreciate it or didn't have the proper authority, and now I, the attorney, maybe have a little bit more leg room to push for more and a fairer offer. The other thing is after depositions, and what we're talking about is the live depositions, again, where we prepare you to testify, and let's say you did a great job. I want to be clear, a lot of people think depositions are difficult to deal with. In my experience, depositions actually can be very helpful. You got to think about a deposition in a lot of ways as a job interview. And what I mean by that is it's an opportunity for you to prove to the attorney what a great witness you're going to be at trial. And in my experience, the attorney then goes and writes a report to their supervisor about what a great witness you are. And if you come off as a good witness, that's going to help us and help the adjuster evaluate the case. In many instances, at least from what I'm hearing for defense attorneys, that deposition actually may have to happen before they even have the authority to settle the case. Maybe their supervisors say, look, we need to at least get them on record to check off that box. So I've seen cases in many instances resolve after depositions. Other times is after expert witness designations, after we've essentially established that our expert's willing to come and help. They've willing to support, and they fully form their opinions. They know what they're talking about. And same thing with expert designations. Also, sometimes after expert witness testimony, in some instances, in many instances, we'll have the experts testify by video because it's much cheaper. And once we have them testify, now the defense, just like they had an opportunity to hear what a great witness you are, now they've heard what a great witness your expert is. So that can also happen. And the last anecdotal experience where I see cases often settle is on the eve of trial. And what I mean by this is like literally the night before trial or the week before trial, as things are getting worked up. I want to be clear, defense attorneys are pretty busy. They usually have a lot higher case volume than us plaintiffs because they're a lot of times in-house counsel, or they're working on contract with insurance companies. They've a lot of times got a huge trial schedule, and sometimes they just don't have the opportunity to really analyze your case or get proper authority from their supervisors until just on the eve of trial. One thing that I always say when insurance companies aren't being fair is we need to file suit to get a deadline. Deadlines, in my experience, move things, and they move money too. And sometimes just because of priority and timing, the adjusters, the supervisors, the attorneys aren't really paying attention to your case until literally they see a case ready up for trial. Other reasons is they see, again, this goes back to us being prepared, they see that I'm ready to walk into court on your behalf. We've got everybody flying in or driving in. So that's another opportunity when the case may settle. Again, this isn't an exclusive list. It's not the end-all be-all, but just in my anecdotal experience. Now, what if the case doesn't settle at all? And this is really an easy answer. Don't worry, we're prepared. So we'll go to trial. And again, that kind of goes back to my philosophy. Don't fear the unknown. If we've prepared, we're confident. And by preparing the case, we've also thought through the case. It's allowed me to properly evaluate it. It's allowed you to properly evaluate it, think about the cost benefit and all that. But if it doesn't settle, we've had a discussion by then, and we've both agreed that it's in your best interest to put the case to trial. And we like trying cases. Now, what actually happens at trial, again, that's going to be subject for another video. But don't be worried. We can't operate from a place of fear. If we fully prepare for your case, we've thought through the issues, we know our weaknesses and strengths. Even if there's a huge issue that we're well aware of, at least through talking it through, we're aware of it, and we can feel confident that we know that we're ready to address it. Now, look, I will say, if you found this video helpful, share it. If you've accessed this video by YouTube, it's pretty easy. If you accessed it by abreniolaw.com, you can actually click on the video and it'll lead you to YouTube. But part of what we're doing here at Abrenio Law is trying to educate the public. Even if you're not a client, I'm hoping this information will be useful. Now, of course, it's not legal advice, but it helps kind of guide you on how we operate. And I think most good attorneys have a similar process, and they understand these rules. And as far as timing, the rules apply to everything. There's scheduling orders and statutes and deadlines and all that kind of stuff. So share the video and subscribe to our YouTube channel. We also have social media accounts at Twitter and Facebook there at Abrenio Law. Facebook, that you can just Google Facebook, Abrenio Law, where we are constantly trying to share videos, update on what's happening at the law firm, but also useful changes in Virginia law. We have discussions about policy. There's also my contact information. You can go to www.abreniolaw.com, and there's my email, james@abreniolaw.com, and my phone number, 703-570-4180. Look, I know this has been a longer video, but I appreciate you sticking through it. Hopefully it's been useful, whether you're a client or not. Of course, if you have other questions, comment below. Also send me an email. I'm always looking for good content, and the way I get good content is I think of good questions, or I have questions that I think people need to hear the answer to, that helps inspire me to do these videos. So thanks a lot. Hopefully I get to work with you. If not, then hopefully this has helped you be in a better position to make the best legal decisions about your case, and I wish you the best of luck. Thanks.